Welcome everyone to today's webinar from the ABA's section of Civil Rights and Social Justice. Thank you all for joining us. We encourage you to check the section's website at www.americanbar.org/CRSJ and check out our Facebook page and check us out on Twitter. Our handle is @ABA_CRSJ for more news and information and replays of our great programming. If you like our work, we invite you to become a member of the section of Civil Rights and Social Justice and collaborate with us on projects you want to develop and offer to members and our general public. There will be a Q&A at the end of today's program. If you have any questions for our panelists, you can type the question into your question feature in the dashboard. And thank you for all our panelists and our moderator for participating today. We're so glad you're here. And our moderator today is Christy L. Bowman, Vice Dean for Academic Affairs and Professor of Law at Michigan State University College of Law. And with that, take it away, Dean Bowman.
Thank you, and welcome to everyone who is joining us today. We have an absolutely wonderful lineup of panelists, and so I know that you will learn a lot from them, and I'm certain I will as well. So I'd like to dive right in, and I'll let you know who we have on our panel today, and then we'll turn it over, hear from them, and at the end we will have time for questions from all of you who are joining us. So first, we will start out by hearing from Maggie Solomon-Ross and Shade Bine-Amissa. So Maggie has taught reading and writing for 13 years in Philadelphia and Baltimore public and charter schools, grades 6 through 12, so quite a range of experience there. And she also has coached pre-service teachers as a curriculum specialist through Teach for America. Her bachelor's degree is from Ithaca College in English and Spanish literature, and her master's is from the University of Pennsylvania in teacher and curriculum development. And her husband, and 2 boys currently live in Philadelphia. Her oldest son's a kindergartner in a Philadelphia public elementary school where Maggie volunteers. So welcome, Maggie. We're glad to have you here. Shade Bine-Amissa. Shade has dedicated her career to empowering youth to overcome the realities of inequity in education. After completing her bachelor's degree at Temple, she began her career in 2011, also through Teach for America. And through this opportunity, she began teaching African American history at a local charter school in North Philly and has taught there for the last 7 years. She also went on to complete her master's degree in education at the University of Pennsylvania. And because she wasn't busy enough, she went to law school. So she has recently completed her first semester of law school at Delaware Law. And upon graduation, I think sounds like she is headed into educational equity, which will be very wonderful to see. And I look forward to hearing about what you do in that role. So we have 2 more panelists as well. Michael Rebell. Michael is the Executive Director of the Center for Educational Equity, and he is a Professor of Practice in Law and Educational Policy at Teachers College, Columbia, and he also teaches at Columbia Law School. He has been very involved, in fact, was the Executive Director of Campaigns for Fiscal Equity, co-counsel for plaintiffs in many important and significant school funding cases. Also, he was involved in Jose P. versus Mills, and that had a plaintiff class of 160,000 students with disabilities. He has been a court-appointed special master in a Boston special education case, and currently he's co-counsel for plaintiffs in New Yorkers for Students' Educational Rights versus State of New York. He has written or co-written 6 books, dozens of articles, and if you are just diving into school finance law, I highly recommend that you pick up anything that Michael has written. Just start there and keep on reading. He is an accomplished litigator and scholar as well, and I have the sense that his practice and his scholarship both inform one another, and hopefully both are the more rich for it. I can certainly say his scholarship is. And finally, it is also a pleasure to introduce Harold Qualwasser. He is the author of Renewal, Remaking America's Schools for the 21st Century. Hal is the principal consultant of Renewing Our Schools and previously was general counsel for LA Unified School District. And prior to that, he was deputy general counsel for U.S., do I have this correct, Department of Defense?
Department of Defense.
All right, interesting. So he's held various political positions and was a partner for Tuttle and Taylor in LA. A while back, I imagine he clerked for Judge Max Rosen on the U.S. Court of Appeals for the Third Circuit. He's a graduate of Swarthmore and Yale Law School. So that is our wonderful collection of panelists for today. I'll just let you know briefly who I am. So I'm a professor and the vice dean here at Michigan State University College of Law. My work has focused on education law issues for about the past 15 years or so. And when I was in practice, I mainly spent time working at Franzik Sullivan, now it's Franzik Radelet, a firm in Chicago that represented school districts all across the area. And based on that wonderful experience, I was glad when I started teaching to be able to continue to write about the First Amendment and 14th Amendment and governance issues that I found so compelling while I was in practice. So that's my interest in this area as well. It is a great pleasure to moderate this panel. And with that, I will let our first panelist take it away, Maggie and Sade.
All right, so I'm Ms. Viney, as I call her. Ms. Viney and I work together. First, I'm going to share a little bit about the students we serve and the school that we work in. And then I will share with you how that informs the choices that I make as an educator, and how I believe funding impacts those choices and also our students' learning. So Viney and I work together in a comprehensive lower high school, meaning there are 600 to 650 kids, depending on the year. That's spread across just our 9th and 10th grade. Our 9th grade is consistently larger by about 70 to 100 kids. This is accounting for, say, things like attrition, students transferring after their first year, students turning 16 and making different choices educationally. So generally, we have between 600, 650 kids in our 9th and 10th grade, and our 9th grade is stacked with larger numbers. I've been at the school that I'm in now for 6 years. I believe, Viney, you've been there for 7, one more on me. Each year that I have been there, and I would imagine Viney would share this perspective, our number of students with special needs enrolling has grown pretty significantly. So this year's incoming 9th grade class, 40% of our students were identified as being students with special needs, meaning that they have individualized education plans, IEPs, or 504s. Those are legally binding documents that take into consideration students' academic and emotional needs, and then they mandate supports, accommodations, modifications that we are legally required to give our students. So kind of the important number there is that out of the, say, 600 kids in our building, or at least say 300 of them were 9th graders. 40% of those students came in as being identified as students with special needs. An additional layer of information that's relevant to the work that I do and my mindset about funding is that this year's incoming 9th grade class averaged about a high 5th grade reading level. So 14 to 16-year-olds reading, that would be about 4 years below grade level. And that is the average. So legally, it is advisable that if a child falls 2 or more years below grade level in their reading, that they should be assessed and potentially given an individualized education plan or a 504, so that educators and the sort of larger school community is putting additional supports in place to get that student back on track, so to speak, with their reading and math level. So if only 40% of our students come to us are identified as having special needs, but the average reading level within our school is about a 5th grade for that incoming 9th grade, then you can extrapolate that out to imagine that actually probably more than 40% of our students are qualified or should qualify for that named student with special needs and earn the sort of additional supports. So the reason that I think that this information is relevant is, one, I am a reading interventionist, so I teach many of our school's neediest readers. But in sort of the context of school funding, in the years that I've worked in the school that I've been in, we'll say that a student who is not identified as being a student with special needs garners, based on the School District of Philadelphia's price per pupil allocation, between $12,000 and $12,500. So that is what the city and the district believes it can afford to spend on a child being educated in a school. And then when you take into account a student with special needs, over the 6 years or so that I have been at my school, it seems that the average for a student with special needs, their price per pupil allocation is between $18,000 and $18,500. So even if you believe that those price per pupil allocations are sufficient, if you follow sort of my thinking that more of our students would qualify for that additional funding because they should be identified as being a student with special needs, then even if you assume that those price per pupil allocations are sufficient, we are not sufficiently financially equipped to meet the needs of our students. So that's kind of the broad picture. And now I'm going to kind of invite you into our school a little bit and share, if you were in the hallway and in our classrooms, some things that you might see. So and my colleague Viney will speak more specifically to teaching content classes. But the content classes, social studies classes, science classes, gym, music, many of those classes, class sizes are quite large. You would not be surprised to see 28 to 35 kids in our school sitting in those content classes. Think about that classroom with, say, 28 kids. In that room, you have a smattering of kids that are reading on a 10th grade level, which means that they require being pushed, right? They are deserving of and require a cognitive push. And along with that smattering of kids reading on a 10th grade level, you also have kids reading on a 1st and 2nd grade level. So if you have 35 kids in your room spanning reading levels from 1st grade to 12th grade, and you have but one teacher, then it is incumbent upon that teacher to figure out a way to teach all of the kids in the room. Most of the teachers who are teaching content classes in my school are given textbooks or a standardized curricula to work from. That textbook or that standardized curricula assumes that the students who will be engaging with those resources and those texts are reading near, on, or past that grade level. But we know, given the population of students that I serve, that the majority of students in, say, a class like Ms. Viney's are not reading on the level that that textbook is written. So it is then incumbent upon those educators to find myriad ways to differentiate to meet the needs of those kids. So you have teachers working with limited resources. Here is your textbook. It probably is accessible to maybe 30% of the kids in your classroom. Now you need to spend your time finding a way to make the content meaningful and accessible for a vast group of a variety of needs of all of the students that are in your room. I would argue that our amazing teachers, like Ms. Bynum, spend countless hours figuring out how to meet the needs of her students. Countless hours differentiating, finding ancillary materials that will ensure that kids on all levels are engaging with content meaningfully and critically. But Ms. Bynum is able to do that because she is an exceptional educator and she has taught for many years. That is not the case for many of the teachers in our school. Many of them are newer to the profession and less experienced because, as we know, in under-resourced urban contexts, it is oftentimes likely that we have newer and less experienced teachers in our school. So you then have newer and less experienced teachers being given a tiny handful of resources that are accessible to maybe 20 or 30% of their kids. And then they're relying upon those resources only. They're teaching only from them because with their limited experience, that is what they are able to do and share. So the reason that you will see such large classes is then because, given the reading levels of so many of our kids, we have much smaller reading support classes. So in my classroom, my largest class has 10 or 11 kids, because the students that are in my classroom, unlike in the content classes where there's a variety of reading levels, my class is differentiated very, very small scale. So most of my classes are pre-kinder to second grade readers, 6 to 8 kids max. They spend 54 minutes with me at a small table. Many of them are doing different tasks. Many of the kids that are rostered to me in 9th grade will be re-rostered to me in 10th grade so that we can continue the work that we do. For someone like me, I get the great benefit of having small classes. There's a lot less management pressure put upon me. I would certainly share with you all that I feel some guilt that to meet the need of our neediest readers within their reading levels, we need to have hugely overburdened content classes. I would also argue that it means that a lot of our human and financial resources are spent just getting kids to grow to read perhaps on a 5th or 6th grade reading level, to the detriment of our programming in our other content classes. Would that be a good place for you to jump in, Ms. Viney?
I think so. From the opposite end of the spectrum, so as Maggie was stating, I have anywhere from 28 to 35 students in all of my classes, with the exception of one. And I do not have any push-in support. And I have been forced to kind of figure out different ways to meet the needs of students. When I'm not reading books to kind of figure out how to differentiate material, I'm seeking professional development opportunities. I'm talking to students to kind of figure out how they learn, trying to collaborate with other teachers. I spend countless hours on the internet. I will purchase materials with my own money to kind of get kids that, give kids that hands-on experience so that they can still access the material. But it's still extremely, extremely difficult. And with a charter school where we have, in theory, an abundance of money in comparison to our other schools, it would appear as if we would have less of a challenge meeting the needs of our students. But I think that that's kind of an overstatement. I think that we struggle, in essence, more because, as Maggie talked about, we allocate most of our funds to our special education students, but then we have an honors program that is trying to thrive, and they're struggling with getting kids those outside of the classroom experiences, internships, travel experiences. We have to fund those out of pocket, whether it be asking students to pay or creating a ton of donors choose or Amazon wish lists to just get kids to have the experience that they should have if they go to a different school, literally maybe 10, 15 miles away, which is unfortunate, but that is the reality.
So the reason that we wanted to start with 2 teachers was to really provide the context and some details, some thoughts about what it's like to teach and attend an underfunded school, and essentially why funding matters. When we think about the issue generally, of course, it makes sense that school funding matters and the level at which we're supporting our schools is significant. But when we hear about how that actually impacts classrooms, I think that provides a really helpful perspective. So anything else that either of you wanted to add before we turn it over to Professor Rebel for more of a legal overview?
I would just add that teachers are paid a lot here, in theory. But I don't think that people realize how much money we actually put back into the school every day. Here, you know, many days I'm buying pens, pencils, dry erase markers, little things that you don't think teachers would need, we need. On top of, you know, providing food and snacks and things for kids who are struggling to get those things outside of the building. And those things kind of add up. So, you know, someone may make $50,000 a year, but if you think about it, we're probably bringing home about 30, just based on what we do for students every day, just to make sure that they have what we would think is a better education than some of their peers in the same district.
Yes, I guess I would also add, since Ms. Biney mentioned things like donors choose and Amazon wish lists, I think that there is potentially a belief that I'm extraordinarily grateful for those resources because they have augmented my instruction in ways that past my paycheck, as Biney suggested, I would be able to do on my own. But I admittedly, and I don't know of any really of my colleagues who are using those resources for significant enrichment opportunities, because we cannot. My Donors Choose funded a beautiful independent reading library in my classroom with texts that are accessible for the variety of readers that I teach. The kids love them and we read and use them every day, but I would argue that that independent reading library is not an enrichment opportunity for my kids. I believe that the funding that our school receives should provide our classroom and my students with those materials. The same with the Amazon wish list. I publicize mine twice a year on Facebook and through email with friends and family so that people can buy things quite literally like pens, pencils, tissue for my students during allergy season, snacks, rewards, little things that matter to the kids that inarguably they should just have throughout their day to be successful. So although we think we are also grateful for resources like Donors Choose and Amazon wish lists, those are, wish list sounds a little fancier than I think we end up using those funds for. It is quite literally tissue that I need for my classroom right now.
Thank you. So now we will turn from the micro level to the macro level with Professor Rebel to give us an overview of current laws, legal landscape, school finance litigation, all of those issues in a mere 20 minutes. No small feat.
Okay, so I am going to take us back in time a little bit, actually over 50 years, to the famous Rodriguez case, which really marks the beginning of the major court involvement in these education finance issues. But just to jump ahead to where I'm going to conclude, there have been a lot of litigations in a lot of states, and I just want to throw out a couple of facts that always stand out to me. Plaintiffs have won some of these cases, they've lost some of these cases. In New York State, we won. Our average spending in New York City these days is in excess of $22,000. I hear about Philadelphia where it's $12,000. We're not that far from Philly, and I think our cost of living is probably somewhat in the same area. So it's astounding to me that kids in Philadelphia are having virtually half as much spent on them as kids in New York. And plaintiffs have really worked hard in Pennsylvania. They've gone back to court 4 times now. 3 of those times, the court left them empty-handed. And that's why Philadelphia is funded at the level that it is now. Just in the last few months, the Education Law Center in Philadelphia has won a major motion to dismiss issue. The courts have now said the issue is justiciable in Pennsylvania, and it's going back for trial. So if that court finally issues a ruling favorable to the plaintiffs, I think it will have a big impact on what's going on in your classrooms, and that's what we're really talking about. By the way, I would also say the national average of special ed funding is roughly twice what it is for general ed kids. So there again, in Pennsylvania, if your special ed kids are only getting 50% more, that sounds to me like something's a little bit out of kilter. And by the way, I don't want everybody listening to think that the $22,000 we get in New York is somehow the national standard. No, we are #1 in the country in per capita spending. And I get a lot of heat from that, from having brought the litigation here. So I want to take some credit for it with this audience. Anyhow, let me go back to Rodriguez and put everything in perspective on what's going on in all 50 of the states. The Rodriguez case took place in Texas, in the San Antonio area. It was brought in the late 60s. It got to the U.S. Supreme Court in 1973. Now, when we do step back in history like that, let's remember what was happening in 1968. That was 14 years after Brown versus Board of Education. And many of you may know that it took the Supreme Court a little while to get past their notion of slow and deliberate implementation of the Brown Decree. The court essentially did next to nothing for 10 years and let some resistance fester. But by the late 60s, the combination of the court taking a strong stand in Green and in the Charlotte-Mecklenburg litigations, and the push from the Johnson administration at the time meant that you had a dramatic turnaround. And by the late 60s, the vast majority of schools in the Deep South were in fact desegregated. So once you had real progress in school desegregation, people noticed that there was a big challenge remaining, because what was happening in many areas is you had poor white kids attending school with poor black kids, and none of them had sufficient resources to have the kind of educational opportunity that the Supreme Court had been talking about in Brown. So that led to this focus on education finance and the question of what resources were needed and were the resources that were available being distributed in a fair and equal manner. And that's what triggered the case that went to the Supreme Court, known as Rodriguez. Now, we very often say in the law that good facts make for good law. So from that point of view, Rodriguez was really an ideal case. And I just want to take a couple of minutes to quickly go over the facts in Rodriguez because they're so illustrative of the essence of the inequity that we're talking about. I had sent in a handout that has a chart that displays some of the financial facts. Is that available? Where are our technical people here on this webinar? Well, I don't see the handout coming up, so maybe I'll just discuss this quickly orally. What was going on in the Rodriguez case is San Antonio, the greater municipal area around San Antonio, had 7 different school districts. And literally, depending on which side of an avenue you lived on, you could be in the very poor district known as the Edgewood School District, or the very wealthy district known as Alamo Heights. And it won't come as any surprise to you that Edgewood was overwhelmingly minority students, largely Latino students at the time, and Alamo Heights was overwhelmingly Caucasian. The property values in Alamo Heights were substantially higher than they were in the poor neighboring districts. And because so much of the school funding depended on local property taxes, you had a situation where even though the taxpayers in Edgewood, the poor district, taxed themselves at a 25% higher rate than their neighbors across the avenue in Alamo Heights, they could raise literally only half as much per capita funding for their kids as the kids were getting in Alamo Heights. So these facts were quite stark. You know, some people, when they talked about local funding and its virtues, they said local people can decide whether education will be a priority, whether they're willing to pay taxes for it. These people were actually taxing themselves at a higher rate, but their local property values were so much lower than they were in the neighboring district that even with extra state aid and federal aid, they came up with half as much money. And that led to some devastating facts about the kind of education those kids were getting. So these are the facts that went up to the US Supreme Court. And you would think, wow, you couldn't have a more stark set of evidence to convince the Supreme Court that if the Brown vision of equal educational opportunity were to be meaningful, they had to do something about this problem of inequities in educational funding. So people did expect that this would open up a whole new area of education reform, implementation by the courts. But it was actually quite surprising because Rodriguez, I think historically, is seen as the major Supreme Court that announced the end of the Warren era. By a 5-4 vote, the court went the other way. It held for the defendants. And it held, among other things, that there is no right to education under the federal Constitution, or in technical terms, education is not a fundamental interest for strict scrutiny purposes under the 14th Amendment. As I mentioned, this was a 5-4 decision. Strong dissent from Thurgood Marshall, William Brennan, and they argued that even though there's not a word about education in the federal Constitution, nevertheless, there is a First Amendment, there's a 15th Amendment. If kids are going to be capable voters, if they're going to exercise their First Amendment rights, they had to have some level of basic education. And Justice Powell, who was writing for the majority, Powell, by the way, had been the president of the Virginia Board of Education, so he knew education issues. He was somewhat concerned about that argument, and he didn't dispute it. He said, we accept the fact that you need some level of education to be a good citizen, but the plaintiffs in this case have not argued that they're not getting whatever that basic level of education is. They just argued they're getting less money. So they didn't translate the lack of money into actual educational outcomes. So that issue was left for another day. I'm just bringing that up because one of the things that I'm looking into at the moment is whether that latter day has come, and maybe we should bring that kind of federal case and open up that issue. But I'll leave that for later, or the question period. For present purposes, going back historically, Rodriguez said that the federal courts are not going to get involved in this issue of inequity in educational funding. So the doors to the federal courthouses were closed on this major issue. And as I mentioned, this was not what most civil rights lawyers had expected at the time. They thought this was a relatively straightforward case. The facts were so overwhelming, it was necessary to implement Brown. But if that was the clear message, and it was, the only alternative was to go to the state courts. And that had not been the preferred route back in the 70s because state courts were perceived as generally being very conservative, if not hostile to civil rights claims. Procedures in state courts were more difficult. State judges tended to be overburdened, didn't have time for large institutional reform cases. But nevertheless, there was no alternative. The Supreme Court, by the way, had recognized these facts, that recognized the inequity. They said somebody should do something about it, but it's not going to be the federal courts. Go to the state legislatures, go to the state courts. State legislatures were not a reasonable forum for advocates in this area because they had created the problems. They weren't likely to solve them. So that left only the state courts. And as I say, the attorneys at the time were very pessimistic about what the outcome would be. But lo and behold, the first few cases that occurred after Rodriguez in New Jersey, in California, and West Virginia were grand slams for the plaintiffs, really strong decisions holding that under the state constitutions, there was a fundamental right to education, whether under the Equal Protection Clause or otherwise, and those courts issued strong decrees. So the first 5 or 6 years after Rodriguez, you had a string of 5 or 6 plaintiff victories. And when people in other states saw what was happening, of course, there were a slew of additional litigations filed. So by the 1980s, you had more than 24 cases filed in state courts throughout the country. Now, if I said in the late 70s, plaintiffs were winning almost 100% of these cases, interesting phenomenon was when you track what happened in the second round from the late 70s to about 1989, the pendulum swung the other way. There were about 24 cases filed, and at this point, the defendants won about 2/3 of the cases. So that was a bit of a disheartening trend from the advocacy point of view. But again, if you keep track of, you might say, the batting averages or the won-loss figures from 1989 to about 2007, again, there were another 24 or so cases. And this time, this pendulum swung back and plaintiffs won about 67% of the cases. So those kinds of trends, of course, become fodder for analysis by law professors and others. And I have my theories of what was going on with all of that, which I'll explain briefly, and others may differ. But I find it very interesting that 1989 was the dividing point when you look at these figures. And 1989 was the year of the major economic summit, the major education summit, where the first President Bush brought together the governors of all 50 states, business leaders, etc. It was co-hosted by the Governors Association, which at that time the head of the Education Committee in the Governors Association was a guy named Bill Clinton. So Clinton and Bush worked together on this, and that was a phenomenally impactful convening of the 50 governors and the education commissioners. Out of that came the standards-based reform movement, which I assume most of you are familiar with. The idea that if we're going to make progress, in those days we were worried about competition with the Germans and the Japanese. If our schools are going to measure up, we have to have high standards, and we have to orient our teaching and our curricula, etc., to meet high standards. And that standards-based movement morphed into the No Child Left Behind Act over the years. To make a long story short, my thesis is that what was happening in the 1980s with the state courts is that they looked at what the results were of those first state court victories in California, New Jersey, etc., during the 70s. And they were concerned about the remedies and the difficulties that those courts seemed to have in following up on their breakthrough legal doctrines. California, for instance, the court essentially issued the logical result in an equity case, which is to say, if there's such uneven funding, if kids in one district are getting twice as much as kids in another, we'll issue a decree that says you can't have huge disparities. So that's what California did. You couldn't have a disparity of more than $100 between the amount of funding in a poor district and a rich district. Sounded like a great remedy, but as Hal probably knows, many people think it led to Proposition 13, the taxpayers' revolt. And essentially what happened in California, instead of leveling everybody up to a higher level, you tended to level everybody down. So California at the time of the Serrano case in the 70s was 5th in the country in per capita funding. I think last time I looked, it was about 46th. And it has not been a happy result in California. In New Jersey, the litigation that began in the 70s, I think just ended 2 or 3 years ago. That case went back and forth to the New Jersey Supreme Court literally 25 to 30 times. Courts from other states looking at what's happening here were not eager to get involved in a situation where they'd have ongoing litigation for decades. So these were not great examples. And I think that influenced the courts in the 80s, worried about the remedies, worrying about whether there were manageable standards for courts to get involved in these cases. So my thesis continues, once we had standards-based reform, all of a sudden, plaintiffs could go in and tell the courts, you do have manageable standards. And you as judges don't have to get heavily involved in the policy arena because the state legislatures and the state education departments have done it for you. They've articulated these new standards. They've said, here's what all kids have to learn. And those standards are for all kids, rich and poor, black and white. Everybody's supposed to be capable of meeting those standards if the curriculum is geared to it, if the teachers are trained properly, and if they have the resources. So plaintiff's game here was to go in and say, here are the resources. Look at our outcome figures, because No Child Left Behind, of course, had all these accountability standards and quantitative measures. And if the state's saying everybody or 90% should be able to achieve at the standards level, and then you look at what the test scores are, and you see that you're getting 50% proficiency, you're getting 40% dropout rates, well, it's pretty easy to convince a judge there's a huge gap here. And if the state has said all kids can achieve at this level, they have to provide reasonable resources for them to do that. Let me just give you one example. In our New York case, our regents had 5 outcome exams kids had to pass to graduate high school. They still do. One of those was in lab science. Well, to pass a graduation exam in a lab science, presumably you had to take a course that had a lab, a science course that had a lab. Well, at the time we had 100 major large high schools in New York City. 31 of them did not have functioning laboratories. So when you come in and you present that kind of evidence to the court, here are the standards, here's what the state says the kids need to do, but you're not going to give them the tools to do it. It's a slam dunk. I don't have time to get into all of the intricacies of the fascinating doctrines that were developed in these cases. Suffice it to say, overall, if we go back over the whole 50-plus years history of the state court involvement, we've had litigations in 46 out of the 50 states. Plaintiffs have won 60% of these cases. They've lost 40%. Almost all the cases that plaintiffs have lost have been on justiciability or separation of powers grounds. These are courts that think it's a policy area that courts shouldn't get into. Most of the state judges facing this have said, well, it may involve policy, but we have a constitutional responsibility, judicial review, we will get into it. And in the vast, vast majority of cases, once the courts look at the evidence and they see these huge disparities between what's going on in the affluent districts and the poor districts, and they see what the state standards require and the lack of resources that Maggie and Binay were discussing a few minutes ago, it's a common sense thing. You don't have to have an advanced degree in educational policy to see the disparities here and the lack of lineup. So I think that's why plaintiffs have won most of these cases. And as I say, the ones they've lost, by and large, it's because the courts didn't want to look at the evidence. Sometimes the judges reconsider that. Pennsylvania has just been an incredible recent court decision, powerful decision. You had a Supreme Court bench come in and say, 3 times our predecessors refused to look at the evidence and said, this is not a justiciable issue. We just think they're wrong and we want to see the evidence. We're going to let the case go to trial this time. Doesn't always happen that way. So we've had really good outcomes in some cases. We've had negative outcomes. I don't want to say that every case that plaintiffs have won has led to a great result. We've had some complications along the way. Ohio, for instance, you had a really strong decision for the plaintiffs at one point. The court followed it up with a compliance decision. It said the legislature hasn't gone far enough. They need to do more. There was a lot of pressure. Progress was being made. And then there was a judicial election. Some states elected judges. A different group of judges came in. They didn't want to deal with this. And they just said, okay, we're issuing a final ruling in this case. Our ruling is the legislature's still out of compliance. They weren't going to overturn what their predecessors had done. But the court shouldn't get involved in this. So we're announcing they're out of compliance. We're terminating the case. We hope they'll do something to remedy it. But if they don't, we're not doing anything further. Well, once the court announced that, there wasn't much more progress in Ohio. So you get those kinds of results. On the other hand, you get results like in New Jersey, where as a result of that Abbott litigation, it took 25 or 30 years. But right now, kids in the poor districts in New Jersey on a per capita basis in Newark and Camden and Union City, they're getting more money paid for their education than the kids in the average of the 100 most affluent districts. So that's the result that should have come out of Rodriguez, and it did come out in New Jersey. We've had tremendous progress in some of the school districts in New Jersey. Union City that I mentioned, virtually all Latino district. They're among the highest performing schools in the state, all Latino poor kids, and they're at the level of the best of the affluent suburbs. That's not true in Newark, it's not true in Camden, so it's not a panacea, that's for sure. But let me just say, one of the major research studies that was completed just a couple of years ago by Jackson, Johnson, and Persicchio, published by the National Bureau of Education Research, they've done the most extensive analysis of the overall pattern of success in these states. They studied Supreme Court decisions in 28 states between 1971 and 2010, and what they found was a 20% increase in annual per pupil funding that came from these cases led to almost one more year of completed education. And in addition, these students experienced 25% higher earnings after they graduated. There really has been a positive impact on average from this pattern of state court involvement in these education funding cases. And I think I've probably run out of time. So the last point I just want to make on this, especially since this is an ABA webinar, an interesting fact for lawyers to take into account is that in the 200+ years of American history, this area of education finance and education adequacy has been the most extensive area of constitutional involvement of the state courts in American history. There's no area that the state courts have been more involved in, have developed more extensive legal doctrines, have experimented with a greater variety of important compliance remedies, and it's become the virtual laboratory of the states that Justice Brandeis talked about in the early 1920s when he said the glory of our federal system is the laboratory of the states. That's what we've had in the area of education finance and education adequacy. Thank you.
Thank you for that wonderful overview. The legal landscape is definitely a complex one, and you've given us some very helpful information and a nice context that intersects with the classroom level conversations we had previously, I think, in a very helpful way. I will note a question was asked about the handouts, and those are available if you go over to the right side of your screen menu. There is a tab that says handouts, and if you click on the arrow just to the left of that, you can see the handout. I believe there's one that says Hal Quasar document. Hal, I guess that's yours. And the handout, and I think that one is Michael's. So for our listeners, that's where you can access those documents as well. All right, turning it over to Hal Quasar.
Well, thanks very much, and I'm pleased to join all of you in doing this. My role here is, so what happens when you don't yet have a great lawsuit that's bailed you out and you have a legislature that hasn't seen fit to give you the kind of money you think you deserve? So this is a practical discussion of small things that you can do to at least help you through the financial situation that you face, even if they don't present these great solutions that make you entirely happy that you're now a well-funded school district. But, you know, in terms of practicing law and in being the general counsel or the chief outside counsel for a school district, these are the sorts of things you can do today to earn your money and make you feel at least as if you're contributing to the solution to the problem. First point, I don't want you to think about this just as a funding question. What you're trying to do is to get your spending in line with your resources. So you have to worry, or at least offer advice, about both how the district spends its money and how it and where it gets its money. So I'm going to read this because I think in my 20 minutes, I've got a lot of small solutions and nothing big, but there are a lot of them. And if I just sort of talk amiably about it, I'm going to run out of time before we hear the last 4 or 5. So if I drone on a bit, I apologize at the outset, but bear with me. Somewhere in here, I think there's probably a nugget or two that you can take away and use usefully. So the first thing you need to do is to know what you are really likely to need. Now, what do I mean by that? There has to be a serious planning process that, for example, looks into how many students you're going to have and what costs, if any, are likely to change in the coming years. Too many districts don't look at the data. They simply extrapolate from prior years and then get caught out by changes they haven't anticipated. Now, there are two ways in which lawyers can play an important role in making this happen. One is to counsel the board on how to create a planning and budgeting process that relies on real data, which of course means generating the right data in the first place. And I am confident from having consulted with districts around the country for years, that is a great challenge. Second, it means looking at contracts and other district obligations to see if you can minimize or hedge risks. In the Northeast, for example, that might mean looking at your heating oil suppliers. Are your contracts hedged so that the cost of heating oil goes up significantly and quickly? You're protected against the rise. Next thing, you need to look at total quality management, Six Sigma, or some equivalent continuous improvement mechanism. Now, I've worked with or observed probably 50 districts over time, and they've committed themselves to continuous improvement. It really does work. If any of you need to have some proof of that, look at the Baldrige Award winners. Each one has combined high performance with relatively low cost because they've used continuous management strategies to improve quality and reduce expense. Schools resist continuous improvement for a variety of reasons, but you need to remind your clients that funding becomes easier when things become more efficient. Now, your biggest costs are salaries. For most districts, pay and benefits gobble up something between 70 and 80% of total expenses. As the district lawyer, you either negotiate labor contracts or certainly can influence those who do. In my experience, there are various ways to keep those costs at a minimum. The first rule of labor relations comes from total quality management or Edward Stemming or Peter Drucker or any one of a number of management gurus. And that is respect your workforce. It really does make a difference when labor feels it's being treated fairly. And as a former general counsel of a district that had really poor labor relations, I can assure you that deals are easier to get at the other side of not trying to even some prior score. And the second rule is that we're in a period of transformation in our schools. Nothing need be as fixed as before. And by that, I mean that not every teacher need be in classes 6 hours a day, and not every teacher needs to be doing a stand and deliver routine. I'm sure both of our teachers on the panel agree with that. But what that does is it gives you flexibility to think about creative reimagining of teacher job descriptions and hours, which can lead to the more efficient use of salary money. Finally, there's some things that mean spending more in the short term, but which save you financial distress in the long term. What I specifically have in mind is pensions. Pay for them when you are supposed to. That means more money up front and more political stress, no question. But it also means less financial distress when the actuaries appear reminding you that you face bankruptcy because of unfunded pension obligations. See Chicago as an example of that. Similarly, spending money on serious teacher induction processes that help new teachers learn the ropes save vast sums in the long run because it cuts down on teachers leaving. There have been several studies that say nationwide, we spend something on the order of $10 billion a year $10 billion a year on teacher induction and teacher turnover issues. And smart management of that problem can cut those numbers substantially. Finally, attack high cost items fast. Why am I saying this to a bunch of lawyers? It seems like a management issue, not a lawyer issue. The potentially most draining and troublesome cost in most school budgets is special education. Maggie, we didn't talk about this, but we're on track to focus on the same thing. A badly managed special ed program can impose millions of costs that can be avoided by aggressive, early search and serve and good quality services that reduce demand for private education and other more expensive alternatives. The LAUSD special ed budget when I was there was about $1 billion or roughly 11% of our operating budget. I'm confident that we could have cut 10 to 20% of that amount if we'd been better at doing our job in the first place. One more point on keeping on top of special education. In a competitive marketplace with school choice, some of your competitors may try to dissuade parents with seriously challenged special ed kids from applying. To a lesser extent, this happens with English language learners as well. It is to a school's advantage, unfortunately, to limit such children because a significant piece of the cost comes from funds that might otherwise go to the general education budget. Now, I'm not counseling you to be one of those schools shirking your obligation regarding special ed kids. But I encourage you to be vigilant that your competitors take the obligation equally seriously. Otherwise, you wind up at a serious economic disadvantage. Now on to the funding sources, which is where I think the major interest probably lies in this conversation. First, let me break it down and talk about the money you have, and then let's talk about how you can expand that through finding new resources. First of all, I can't do details. There are 50 states. They all have idiosyncrasies in their budgetary processes, and I think that what we've got to talk about here that's useful are the common items that that can speak to the condition in all the states in the district. First, there's the point about the funds. They're not all equal. Local taxes, principally property taxes, and state taxes make up, or state support make up roughly 90% of most school budgets, with the feds making up the rest. As much as those local taxes are often the source of terrible inequities, they have one great advantage. They're general funds. They're not specifically dedicated to a purpose. And two, they're rather stable. Except for the recession years of 2007, 2008, local property taxes rarely declined, except in districts that lost major industries. In comparison, state taxes often go in large cycles, with results that if you rely heavily on states to fund you, you are far more at risk of seeing your budgets wax up and down with some frequency. And then, of course, there's this question of categoricals. About 35% of state support in most states is categorical money, which can only be used for specific purposes, and virtually all federal money is categorical. Your jobs as lawyers is to learn the intricacies of this, not for the purpose of keeping your client within the law, but for helping your client have as much flexibility in the use of those funds as possible. At LA Unified, I had one lawyer whose sole job in life was to understand the intricacies of categoricals to make sure we could use them for as many purposes as possible and still stay at least barely on the right side of the law. Now, some states have the problem that between January and April and May, there's budget turmoil. You never know how much you're going to get. One day it's up 100 million, next day it's down 200 million, and your budget process is totally frozen. You as lawyers can do something about that. First, budget with contingencies that are worked out in advance with your unions, and if you're really aggressive with your suppliers. Don't leave those accommodations to that spring period when all turmoil is breaking loose. See if you can use your ability as a lawyer to work out arrangements where those things are addressed long before they occur. Second, set yourself a long-term political goal of trying to get your state into a funding process that doesn't leave you completely frozen for a third to a half a year. Second, state money depends on headcount on a given day in the fall and generally on a given day in the spring. You, the superintendent and the principals, need to make sure every student shows up for a headcount. Plan events for those days that will draw students in. If you undercount your students, you leave money on the table. And one more caveat. If you have competing schools that can counsel out students, remain vigilant to see that significant numbers of those students aren't arriving on your doorstep immediately after headcount day. Yes, this does happen. That can be a major money loser since you'll have to educate those students without the necessary state funds to do so. Although I'm not going to discuss potential litigation remedies here, if anybody wants to talk about what I think can be done on this subject, send me an email after the webinar. Third, for districts that must put their budgets to a district-wide vote, recognize the need to mobilize voters, which means building a case for the budget by having an inclusive budget process that brings in community voices and then campaigning for passage of the budget, supported by a clear message of what the money is for. Spend the money on polling, know what concerns your voters. And, for those of you who say, why are you telling this to the lawyers? Because truthfully, in most districts, management is thin. The lawyer is as close to a political consultant as you're likely to get in those districts, except maybe for one or two highly politicized school board members. It is important that these budget votes pass on May 15th and that you know what you've got as soon as possible. Otherwise, dollars that arrive late or in a confused package really aren't as effective as dollars that come on time with clear purpose. Fourth, you need to think about building reserves. In my opinion, which I recognize not everyone shares, most districts would choose stability over a bit more money in a given year. The best way to do that is to build a reserve. before working at LAUSD, as you were told, I was the Deputy General Counsel, Legal Counsel at the Department of Defense. One of the great differences I noted between DOD and the LAUSD was that the DOD budget was actually quite stable. Even if DOD wasn't getting as much money as it wanted, it could better plan than LAUSD because it knew what the level of its support was going to be. In LA, we never knew, and our ability to just fundamentally improve the district was on hold for months at a time because we didn't know exactly what we were going to spend. Which gets us to the subject of federal funds. In the Obama era, at least toward the end, things were stagnant. Funds weren't growing. In the Trump era, stagnation would be a blessing because, in fact, with the exception of a billion-dollar plan, not yet enacted, to give money to vouchers and other choice initiatives, the Trump administration in this year's budget book wants to reduce support for federal education, K through 16, by about $6 billion. Now, it hasn't happened yet, so let's just talk about a couple of things very quickly that did happen with the passage of the Every Student Succeeds Act, because it does help you with your budget in a way. The principal thing is there's considerably more flexibility in how you spend your dollars than there was under No Child Left Behind. Again, small dollars, but it's useful to be able to have that flexibility that you didn't have previously. The greatest degree of flexibility now is in something called the Student Support and Academic Enrichment Grant, which was a block grant that combined various previously individual programs. And you can now exercise considerably more flexibility with that than you could previously. This administration also wanted to eliminate Title II, teacher development, but that hasn't happened. Instead, there is a Title II program. And the good news is that the Title II program now has not only more flexibility than it used to, but it can cover development beyond core academic teachers, such as paraprofessionals who deal with early childhood education. It also allows money to be spent for substitute coverage so teachers can collaborate on various things. And it allows funds to address, and this is important, the inequities in which some students have and some do not have high quality educators. More generally, Title II and Title V funds can be used to satisfy other federal needs or federal goals. And that's a blessed degree of flexibility that previously did not occur. And there are some other additional flexibilities in the new federal law. Rather than take time here, all I can say is use them, understand them. They will help you in some places, although conceitedly not with large new sums, but just flexibility to cover what you have. Let me just say that the general news on the federal funding side is terrible. Other than that, $1 billion proposed support for vouchers and other choice program, the administration also won a victory in last year's tax bill, allowing 529 savings programs to be used for private K-12 school expenses. And there's, of course, the limit on state and local tax deductions, which is particularly troublesome for schools, which rely on local taxes heavily and, to some extent, state taxes. And finally, you all should be aware that the continued pressure on Medicaid will result in less money flowing to schools, which actually get considerable amounts of funds as part of their support for special education students, but also for poor students for whom they provide health services. Now, okay, finally, where can we get more money? First thing is, one traditional source you shouldn't overlook or fail to think about it is your bonding money and what you can get for capital expenses in the district. A few tips, because not everybody can just pass bond issues willy-nilly. There are some things that you need to think about, and these are all lawyer things that you can take care of. First, you need to be creditworthy, which gets back to the point about underfunding things like pensions. Because if you're not creditworthy, you drive down your credit rating and increase your borrowing costs. Second, you need professional managers for construction. I can't begin to tell you how important it is to have professional construction managers. If not, you're likely to increase management costs, and you'll certainly increase the number of litigation cases arising out of construction. Because if you're upgrading or repairing current facilities, you really need to know what's there before you start. In LA, we found after we passed a bond thinking we needed $2 billion to do something, that we had several schools that were loaded with asbestos, and what was originally thought to be work that could be done for $2 billion suddenly looked like work that had to be done with $4 billion. Finally, back to the election point, bond elections are elections. You need to treat them seriously. You need consultants. You need to sell this. And most of all, you need that trust in the community that believes you will expend the money well, which means getting the board and the superintendent out, talking to people in the community and building trust that you are not just good educators, but you're good managers of their funds. Now, the second additional funding stream is grants. There are literally hundreds, if not thousands, of foundations and dozens of state and federal programs that will give grants to districts for special projects. Many districts now receive somewhere from 2 to 5% of their operating revenue from such grants. What's important to know about these grants is that no district should expect success in the grant process unless it has one or more people or consultants who know what grant money is available and who can write persuasive grant applications. Moreover, you as the district council are going to be expected to review the grants to make sure that the terms allow you to do what you want to do, and equally importantly, to know what information you have to generate to meet whatever accountability requirements are set by the grantors. If you want your district to be able to go back to the same foundations for repeated grants, you have to be in the position of demonstrating that you did what you said you would do and can demonstrate that what you did had the expected effect. Some states allow schools to charge fees. Not a good thing in probably a low-income district, but nonetheless, where you can, you need to think about it. Rules are highly idiosyncratic. They change all the time because it's a political football in many states, but I note them just for your consideration. Then there are school foundations. Now, this is an important one because it weighs many districts now, districts and charters now substantially increase their funds available. These districts have created 501c3s that support school activities. The foundations themselves function like traditional charitable organizations. They may receive direct donations from the public and in some instances may be recipients of funds solicited from other charitable organizations. Now, they file with the IRS, they receive tax-exempt status, and are governed by IRS's related state rules. If the funds are collected for the general purpose of supporting a variety of school projects, there's normally some form of consultation with the school community, and normally the meetings are subject to the open meeting laws because this is a government-related institution. Though that is not necessarily true in all states, and it's worth checking in your particular case. What I would suggest is that if you don't yet have a functioning foundation, and even if you only have a small one or one with which you have limited experience, join the National School Foundation Association. It provides training to fundraisers and more general education about how to operate the fund. Now, the challenge with these funds is whether you can build a steady income over the years. If you can, then you can do great things like constantly support music or science and really have some confidence those things will stay in your school instructional package on an ongoing basis. Here in Sonoma County, where I live, Healdsburg, which is a fairly wealthy community with 11,000 population, regularly raises over $400,000 for its foundation. So they put that money to all sorts of extracurricular activities like, music and art and theater, and have a fully rounded program, which is now largely supported entirely by the foundation. Final point, think about joint projects. For example, rather than create a separate class to teach students advanced math, it may be more cost effective to work with the local junior college to have students take classes there. Similarly, rather than supporting the entire cost of vocational class on carpentry or woodwork, the local union or building trades council may be willing to provide a teacher and or other support. And don't forget about local community and fraternal organizations like the Rotary, the Elks, the Chamber of Commerce. It's often part of their mission statement to help education. They can provide volunteers, facilities, money, but you do have to ask, A related point, ask yourself if there are economies of scale that can save you money. Some states like New York have a formal system of regional support organizations, which they call a BOCES, that are schools purchasing agent and or the operator of specialized program, like special education. If you don't have a formal structure, you can reach out and create informal ones or join for-profit organizations that can use their collective bargaining power to achieve cost savings. Finally, there's one other way to raise money. If you're in the choice area, go get more students. You know, there's a, you know, state funding is dependent on head count. Rather than having a declining enrollment and feel the need to further cut your budget because you have fewer students, go out and tout yourself. If you're a good district, be proud of it and try to bring students in from surrounding districts because you provide superior education to what they can get us. Same is true with charters. So with that, I hope somewhere in there's a bit of information that will help you in discharging your daily work as a lawyer for a school district. Underfunding is perpetual. It isn't really getting better. These are sort of minor solutions, but I hope they help some. Thanks.
Hal, that was fantastic, and I think it really helps us bring together this conversation, thinking about, all right, we're dealing with all of these needs at the classroom level, and certainly litigation is an incredibly important aspect in terms of solving this problem if the state legislature is not willing to step in and fund schools adequately. But of course, litigation is a long, long process, and it's not successful in every state. Michael has had some wonderful successes. Michael, perhaps we need you to move here to Michigan and see what see if you can work your magic here. So Hal, I know your comments are appreciated by a lot of folks across the country, and I know there are a couple of folks from Michigan who are here on the conference, so I'm sure they appreciate it as well. All right, folks, so we have about 20 minutes left for questions. First, I need to let you know, and I was remiss in not informing you of this at the beginning, but this webinar is in fact intended to highlight the first pillar of the Education Bill of Rights. And that is something that the Civil Rights Social Justice Education Committee at the ABA annual meeting in August 27 was rolling out already. So this is the first webinar. There will be follow-up webinars. So keep enjoying the rest of this one and keep an eye out for future webinars as well. And those will address other pillars enumerated in the publication, the Education Bill of Rights. So great work by the Civil Rights Social Justice Education Committee. All right. So I get to moderate some questions here. Please type in questions over on the right-hand side as they occur to you. I see a couple of questions for Michael and then a question for our teachers as well. So we'll start with one for Michael, and then I'm sure there will be questions for certainly all of you by the time we get through here. Okay, so here we go. All right, and I'm just reading this question. Do you consider Sheff versus O'Neill from Connecticut a win for plaintiffs or not? The court left it to the legislature to come up with solutions for the constitutional violations. What's your view on what's happened since? Is there enough progress to consider it a win on remedy and outcome as opposed to a win on the constitutional issue? Interesting question.
Okay, well, first of all, let me just say, I think our topic for today is education finance cases. And I know Sheff was filed partially as an education finance case, but the decision was a desegregation decision. Right. And it didn't press the Connecticut legislature to do anything really about funding. I'll have to leave it to the desegregation experts to say whether it's been a full success. It's certainly been a partial success. It has led to the creation of a large number of magnet schools, especially in the Hartford area. There have been a lot of demographic changes that it's hard for magnet schools or anything else to keep up with. So not all schools in the Hartford area are reasonably desegregated, but more African-American kids go to schools with white kids in that large suburban area in Hartford than before. You'd have to look at the exact numbers and make a judgment about whether wherever you're coming from, you think that's a success.
Yeah, and actually your comments also highlight for us that school desegregation and school finance are essentially, they're parallel, right? And so there are certainly intersections. I think of it really like a double helix in terms of how these operate in a lot of ways, but the idea of race school finance is not something.
Oh, sorry. My friend Jim Ryan, who was a departing dean of the Harvard Education School. He's going to be president of the University of Virginia. I used to be on panels with him. He's a real expert on school desegregation. He used to say the area of education finance was a cop-out because we hadn't achieved litigation success in desegregation, and that's really what needs to be done. And again, that's a strong value judgment that I don't know that I want to get into, whether if you don't fully desegregate the schools, you haven't accomplished the mission of equal opportunity. But I can say we've had a lot of success in education finance. I think it's helped a lot. Whether it's the full answer, again, I'll leave to others to decide.
Fair enough. All right, a question for our teachers. So you mentioned there, and I'm reading the question here as well. You mentioned there isn't enough funding to provide the legally mandated requirements for basic resources, especially as the number of students who need individual attention and IEPs increases. But beyond the legal requirements and shortfalls, can you describe what effect, if any, it has on the kids who attend schools where they don't have access to basics like tissues or books, except for the provided by the personal generosity of their teachers? So how does this impact the teachers, and how does this impact the students? Can you talk about that a bit more?
So I will start. I have taught 9th grade, 10th grade, 11th grade, and 12th grade. And I have students who I've taught honors classes, special education history classes, and AP history classes. And what I've noticed is the students that lack access to basic materials, it puts them at a disadvantage when they go to college. So I have a lot of my students who will come back and say, you know, I didn't read this novel here. So when I got to my first college English class, I was unaware of how to identify, you know, main idea or character development traits and things like that. A lot of times our students who are in AP classes, they'll also take classes at CCP, which is our local community college, just to kind of get those college credits and start that college process early. And they often find that they are at a disadvantage. They do not know things, or they didn't have access to the materials that their counterparts have. So a lot of them actually struggle with things like typing. They are unable to type a 10-page paper because they don't know how to type, and they didn't have typing classes in their high school. Like I said, they don't have basic mathematical skills to keep up with their peers, so they're often in remedial math classes. And this simply is because of the teachers that they've had or didn't have, and the materials that they were supposed to have, but they don't.
Yes, I also would add, within our school, given the needs that I've expressed, we have one nurse and one nurse's aide. We have one social worker and one social work intern. They play a pivotal role in ensuring that our kids are available to learn and achieve that day. With only one nurse and one nurse's aide, if there is a medical emergency in our school and the nurse and nurse's aide must attend to that one student necessarily, then the vast other needs that students might need, the resources that we are lacking in our classrooms that they might need to get from, say, a nurse, they are not able to get that day. So they are distracted from their learning because they are missing that resource. Similarly, when it comes to our social worker and our social work intern, we have it's specified many of our students' IEPs that they are meant to have time with the social worker through counseling, through support groups, because those services enable our kids to be more academically ready, more capable of learning that day. If there is an emergency where a social worker is drawn to help a student who is in, say, a mental health crisis, then every other child that I say she because both of our social workers are female in our school, then they are then drawn away from their caseload of kids that day, that caseloads of kids being reliant upon that FaceTime with those supports to help them learn in school. They are then drawn away from working with that caseload. And it is inarguably true that when our students are not receiving services that they rely upon to be academically and emotionally comfortable in our school, then they're not learning on pace. So not only are our kids, generally speaking, coming to us with deficits in their learning, but then because we don't have the adequate resources to keep up with what the kids' specified needs are, we are sort of continuing having our kids fall behind because they have missed having the resources that they need.
Can I add something here? There are 2 points I really want to make. One is that the Trump administration's budget proposals will exacerbate all these problems. One of the things they want to eliminate is I think it's $1.2 billion program called 21st Century Learning, which basically funds after-school programs. Those after-school programs are a great way to make up some of the deficit, and this administration wants to cut those out. Similarly, as I said when I spoke, they want to cut out, or they want to reduce Medicaid, and in fact also the food stamp program, CHIP, both of which will further complicate life for low-income kids. The second point is, if you thought it was a problem when learning came through books, the big divide is the digital divide. You have kids who do not have connectivity at home versus kids who do have connectivity. The ability of a kid to learn vast volumes of materials is expanded exponentially when they have connectivity at the house. Now, in California, we actually have a state law that mandated all school children have school books at home and at school. So we have to provide 2 sets. I'm not sure that made a lot of sense in the book era. It certainly makes a lot of sense in the era of the internet, but the state has yet to take on the obligation of essentially wiring out the state so that every child can have the same resources at school as at home. But until they do, we're simply going to have a greater and greater disparity between kids who are wired in and kids who are not.
Thank you. So let's turn to another question, and this one is directed to Michael. So I think we'll start with you, Michael, for responses, and then open it up to everyone because it touches on issues that you all have raised in various ways. So here's the question. Please comment on whether there might be a difference between guarantees for adequate funding for general education students and special education students. Thinking about the mandates in federal law for FAPE for special needs students, what might be the role and responsibilities of state governments for picking up the funding for special ed mandates required in federal law?
Well, I think any state that's taking money under the IDEA, which these days is, I think every single one of the 50 states, they're obligated to provide the services that are spelled out in the federal law. And it's true that the federal government, I think, provides something like 14% of the overall cost of special ed now. But if you take that 14%, you're obligated for the 86% or whatever it takes. There was a litigation a number of years ago in the Sixth Circuit that had that issue directly on point, and I think there was a split between the en banc panel. The case never went up to the Supreme Court, so there may be a slight legal uncertainty, but I think the better reading of it is that if you take federal money, there's strings attached to it, and in this case, the string that's attached is that you've got to fully fund special ed. Not saying every state does, and you know, that's another area of active litigation that in many places kids are not getting all the services that are spelled out on their IEPs. On the other hand, I do have some compassion for school districts because a lot of these costs are enormous, and the state aid doesn't keep up with it, the federal aid doesn't keep up with it, and kids have rights. So I like to keep pushing those rights for the kids. It does push the taxpayers, it does push the legislatures. They don't fully come through, but it does move us in the right direction when we look at what the positive slope is, both on increases in funding in general ed and special ed, and the outcomes that do flow from those increases in funding.
Thanks. Any other panelists wanting to comment on that? All right. We have a long list of questions here, and I think only about 7 minutes left, so we'll just keep moving. So Hal, this question I think is for you. Do you have, and I was wondering this as well, so I'm glad someone asked, do you have any insights on consolidation of school districts or creation of regional districts to pursue economies of scale in finding funding solutions? Any thoughts on that?
Easier to talk about cooperative activities. As Professor Rebel knows, New York has a really good system called BOCES, the Boards of Cooperative Education Services, which really does try to provide both purchasing power economies and service economies to smaller districts that can't financially be cost effective. And I encourage those. Consolidation is a very tricky thing. I live in Sonoma County. We have 40 school districts. The immediate suggestion from anybody who has studied this and thinks rationally is, oh, well, gosh, we need only about 2 or 3. We've had innumerable school board members lose their seats and superintendents lose their jobs, however, for even suggesting that any of those 40 be merged. So it brings forth all these sort of strange parochial instincts that are hard to control. I think that consultants like me will tell you consolidation is the way to go if you're talking about the bottom line, but you ask parents and they just want to be left alone. And it's a very difficult subject to address rationally.
And I think your comment highlights something that's important for us all to remember, is that education is a very political issue, right? It's something about which people care significantly, and local communities really have a stake in thinking, okay, this is something we can have a say in this, we can control this. And so especially if we're thinking about removing the local school district, or even just consolidating one school with a neighboring school, or one district with a small neighboring district, there can be a lot of political pushback. And so especially when we're thinking about something like a bond campaign or going to the community for additional support, it's all something to keep in mind, because it's all certainly connected in that regard. Okay, here's another question. Here we go. I'm curious to know if there has been any litigation around using the Common Core standards to show that students are not receiving, at any rate, a question about not meeting national standards, and whether that's the approach in litigation. Basically, the idea, I think, is to say that we need to meet national standards to be at grade level and related litigation.
Well, the state court litigations have been largely successful, I think, because lawyers have taken advantage of the fact that there are very specific state standards. Now, the Clinton administration, the first Bush administration, tried to get some kind of national standards. Obama pushed the Common Core, which supposedly was arm's length from the federal government, but they gave a lot of encouragement to the private groups that put them together. But we don't have national standards, and even Common Core is modified by each of the states. From a litigation point of view, you need standards, and the standards in your own state are good enough, because most kids in the low-income areas, at least in the rural areas and the urban areas, are not meeting them. There is a potential for a federal litigation. I don't have time to go into it. We're seriously considering it. I think there is an opening to revisit Rodriguez, but right now we don't have national standards. Maybe we should, but the litigation route, the primary route, is a state one. By the way, before we sign off, I'll just give a little plug for our website, which we keep track of the developments in these litigations in all 50 states. So especially for attorneys or school people who want to know what's going on, it's at www.schoolfunding.info. That's one word, schoolfunding.info. You'll see a map of the U.S. You can click on any state, and it'll tell you what's happening in the litigations in that state.
All right, thank you. So a couple of other comments, and this one I want to highlight for the organizers of this. A question: this webinar doesn't count as CLE credit, does it? I don't know the answer to that. I'm sorry, but I'm sure our organizers will. So I would like to ask one of them to answer that message on the question or send out something perhaps to the folks who are wondering about that. And additionally, I am mindful of time, so I will share this one last comment that came in from someone who was attending today. And this person says, and I agree wholeheartedly with this, I just wanted to thank you all. I learned a ton of useful stuff this afternoon. So great hour and a half. Thank you everyone for a really informative and thoughtful webinar. I hope everyone joining us has learned as much as I have. And I wish you all well and have a good night.